Court of Appeals is now in session.
Good morning, Council. Nice to see you again, Ms. DAKIC. It's been forever. The Court of Appeals is hearing arguments in several cases this morning. On the calendar at the moment is Sara Ward versus Meredith McGarry. This is case number 2020-0435. The time is set for arguments. I think I overheard Ms. Collins explain both sides have 15 minutes in which to make their arguments. And it appears, Ms. DAKIC, that Ms. DAKIC, that you are reserving 5 minutes for rebuttal. Awesome.
Yes, that's correct.
Thank you. I am sorry, I am discombobulated. Cross appeals, that got me all confused, and I'm really sorry. So this is just normal. 10 minutes to make your argument and 5 minutes for rebuttal. If there are any problems, please, we've been conducting virtual arguments for the past year. Generally, everything goes smoothly. If there comes a time, though, that you have any trouble hearing, any trouble connecting, please let us know as soon as you can, and we'll stop and fix the problem and go from there, and make sure to give you any time that you need or that you have lost while you were not connected or having problems. We will also do the same. If we can't hear or if we are getting lots of feedback or something, we'll make sure to let everybody know. We will try and keep our microphones muted during the argument. And if we have a question, we'll try and get your attention so as not to interrupt you while you're making your argument. But we will do our best to, figure out a way to ask our question with the least disruption possible. While you are not arguing, if you could please turn off your camera and mute your microphone, that will allow us to focus on the lawyer that is making the arguments at that moment. Counsel, could you please enter your appearances for the record?
Yes, ANGILEE DAKIC on behalf of the appellant, Sara Ward.
OLSEN on behalf of Meredith McGarry, the Appellee.
And I see that
Marty Olsen also here, Your Honor, for the Appellee.
See part of his face on the camera. Do either of you have any questions before we begin? Great. And then, so I would ask you, Ms. DAKIC, to begin.
Thank you. Honorable Justices of the Court, may it please the Court. We are here before the Court on appeal on three main issues. Essentially, the case has been in litigation for an extensive period of time, and largely the delay is due to the appellee's refusal, Meredith McGarry, to provide his full income disclosure. And Mr. McGarry is in fact employed, self-employed, and also has business interests in multiple entities. And under Utah Code 78B-12-203, under Section 4A, Meredith is required, he must produce proof of all necessary expenses required for his business operation, so those expenses can be deducted from his gross receipts. And that simply has not occurred here. There have been multiple hearings, there have been multiple orders from the court for Mr. McGarry to provide these disclosures, and he has failed to do so. Furthermore, under the Utah Rules of Civil Procedure, Rule 26, he's required to submit a financial declaration. He's also required under 26D5 to supplement these disclosures when they are incomplete in some important way. Yes, Justice Harris?
Yeah, so I understand that there are numerous disclosure obligations, and some of them can be quite particular and onerous, and all that is by design and by rule. But what's also by design and by rule is that if the parties think that another party has not fully disclosed things they're supposed to disclose, that party needs to bring that matter to the attention of the court through either what we used to call a motion to compel, and what nowadays is called a statement of discovery issues or some other such motion. And the rebuttal to the argument you're making now that Mr. Olsen's going to make here in a second is, well, there isn't any such pending, any outstanding complaint by your side about their discovery disclosures. In fact, in 2018, there was a certificate of readiness filed by former counsel. It wasn't you, but former counsel filed a statement of certificate of readiness for trial indicating that discovery was over and everything was ready for trial. And I did locate in the file a order to show cause where you were asking the court to hold Mr. McGarry in contempt of court and impose some sanctions on him for failing to disclose some things. But those sanctions didn't include an order asking him to disclose more things. It included things like imposing an income sanction. I think you asked for $28,000 a month, which is less than what the court ended up giving you. So anyway, this is a long sort of Judge Ormian question here. But I guess my question is, what can you point to in the record that is an outstanding complaint by you, either in the form of a statement of discovery issues or something else, that is specifically asking the court to order Mr. McGarry to disclose more things?
Yes, I can point to the record. We actually have had, we do still have our order to show cause pending because it was never ruled upon. We went to the court tried to get the parties to negotiate and settle. That didn't occur, but then the court did not rule upon the order to show cause. And as part of that order to show cause, we were asking to compel for those records and those disclosures. But we also filed motions for subpoenas, and we still have outstanding motions that were never ruled upon. Our second motion for a subpoena of the taxes, that was never ruled upon. And so that is still outstanding in the trial court. Mr. Olsen had filed an objection and a motion to quash our subpoena. We did get one order for release of taxes off of Iron Mountain, which did produce and show that there was flow through of other income from McGarry Holdings as well as McGarry Livestock. So when we filed a motion for the court to order release of those tax records, that's when Mr. Olsen filed the motion to quash. And so the court just unsigned it, but it was never, they unsigned the proposed order, but it was never adjudicated. So those are still pending, and we're still trying to get that information. And there have been multiple times where even when the court, even when Judge McKelvey reviewed the matter, he too couldn't say, he couldn't certify the matter for trial. So even though there was a readiness for trial filed, as pointed out by Your Honor, Justice Harris, certainly Judge McKelvey said that he couldn't get the matter on track for trial. He couldn't give us a pretrial scheduling order. He couldn't give us a trial date because he said we needed to go back to the trial court and still get that income information because where the parties, where there's deficient information about the incomes, Judge McKelvey wasn't confident he could even have a trial on that. So we're in this conundrum where we can't get relief from the trial court, even though the court has ordered it multiple times. Mr. McGarry is somehow the exception to the rules. The rules are very clear. Under 78B 12-203, both parties are required. It says under section subpart 5B, each party shall provide verification of current income. Each parent shall provide year-to-date pay stubs or employer statements and complete copies of tax returns from at least the most recent year. And so again, we haven't had any of that. Mr. McGarry continues to provide heavily redacted documents. I have some documents we've presented at court that Ms. Ward presented at court that the entire page is blacked out. That's not what the court ordered. And the court specifically put a protective order in place because of Mr. McGarry's excuse that he thought releasing any of his credit card statements or tax information would divulge trade secrets. But again, there was still no complete disclosure as far as the financials are required. Yes.
Ms. Douglas, can I ask you about the March 11th hearing in front of Commissioner Sagers?
Yes.
In her order, which she styles as a final order, though it's seems to me that that is a recommendation for a final order. She sort of suggests, or you approved us to form the order prepared by Mr. Olsen, that there was some sort of settlement discussions, some sort of settlement conference. Was that was she referring to the 68B settlement conference? Yes. Or was there some off the record? I mean, because the transcript of that hearing, there is no evidence that was presented. There were no proffers that were made, other than the commissioner accepting the offer, the 68B offer of $30,000 a month for Mr. McGarry's income. Right. Could you just give a little more detail about that hearing and how we got to where we are?
So the litigation in this case has been extensive also, partly because when we file our motions with the court, they often don't get ruled upon. The commissioner often requires the parties to step out and discuss. There have been times when counsel would step out and discuss in the hall or in chambers and try to come up with resolutions or agreements. But at that March 11th hearing, Ms. Ward made it very clear that she was not agreeable to what the court was saying. She made it very clear she wanted trial, and the commissioner had already told her that she had every right to go to trial. Yet then the commissioner said, this is going to be the final order in the case. This is it. We need to wrap it up. That was the court's decision at that March 11th hearing. And that gets to our second point that we also have on appeal, where the commissioner can't make a final order. Even though she says this is the final order, she doesn't have the authority to do so. Case law supports that she can make recommendations for entry of a final order, but she's prohibited under the Rule of Judicial Administration 401 2D. Commissioners shall not make final adjudications, and that's also supported by case law in Cropper versus Cropper. And only a district court judge can enter a final judgment in a civil case. That's the home case. Yes?
If we construe this, as Judge Christensen Forster has implied, if we construe this as a recommendation for a final order, what is it exactly that you think the commissioner did wrong, as opposed to maybe something that Judge McKelvey might have done wrong? But what if we construe this as a recommendation for a final order, which is expressly authorized in the rules, what is it that you think that the commissioner did wrong here?
We were saying that we wanted to get a certification of the trial issues and move forward to trial. So that's what she did wrong. She said, no, when she previously said you have every right to have a trial, at this particular hearing now, she said, no, this is a final order. And even at this March 11th hearing, Ms. Ward raised her objection and said, I still want a trial. And the court said, well, this is the final order. We're wrapping it up. So she was denied her due process. She was denied her right to go to trial. That's where we feel the court erred as far as Commissioner Sagers is concerned. But then we also take issue with the way that Judge McKelvey had handled the matter, because we did approve the order as to form, because that's what Commissioner Sagers had said. So we approved the actual form of order, but then we did file an objection to the recommendation. And Judge McKelvey did not allow a hearing on it. There was not an order issued. There wasn't even a minute entry. It was a simple note on the e-filing system where he didn't do an independent review as required by Rule 108. He has to make independent findings of the law and the facts and the evidence based on the evidence of what the commissioner has done. He can't just simply rubber stamp it as what was done here. And so again, we take issue with this. This is problematic, and I see that I'm out of time. I want to have my reserve rebuttal time so I can submit on that.
Thank you, Your Honors. Oh.
I was just going to ask if my colleagues had any further questions. It appears not. Thank you, Mr. Olsen.
Thank you, Your Honors. If it may please the court, I'd like to address the three main issues that she has in her appellate brief today. The first one is the failure to comply with Rule 26.1 of the Utah Rules of Civil Procedure. As the court's aware, if I may go over that just briefly, part of the biggest issues with the Rule 26.1 is the first thing that you have to do is you have to file a financial declaration, a complete financial declaration. Our client did that on April 8th, 2013. He supplemented on May 24th, 2013. He filed another one on July 26th, 2016. and then again on August 28th, 2018. Part of Rule 26.1 makes you provide the last 2 years of tax returns. As seen on the record, for the last 2 years of tax returns, my client not only gave the last 2 years, but the record will show that he provided tax returns from 2010 through 2018. Now, also part of Rule 26.1 disclosures require you to provide tax documents if you're the majority owner of an entity. My client owns 25% of the entity. He's not the majority owner of those entities. Notwithstanding, though, we still provided 2013, 2014, 2017, 2018. She also got a subpoena approved by the court where she got the tax records for 2017 and 2018. We provided pay stubs. We provided numerous documents related to financial statements, bank records, et cetera, et cetera. As you can see, as part of the record of 4852, that is a non-exhaustive list of what we provided for purposes of our client's financial disclosures. And even with our financial disclosures, we still believe that he was only making $14,000 for purposes of child support obligations, yet he was willing to be imputed to $30,000 for purposes of getting this case resolved. One of the main reasons for that is...
Mr. Olsen, can I ask you about that?
Absolutely.
You say he's willing to be imputed, and obviously that's exactly what happened here. Was there ever a stipulation on the record? Was there anything in writing other than the offer of settlement that were made and not accepted? Is there an actual stipulation in the record? Certainly at that March 11th hearing, Commissioner Sagers did not take proffers, did not take evidence, unless there was information not contained in the transcript of that hearing. Where does this stipulation occur in the record?
So I can point to you in two areas. Number one, you already mentioned it, was Rule 68. Those were pending before the court at that time. And then if you look at the record...
Can I interrupt you?
Yes.
Those weren't pending. Rule 68, first off, Rule 68, I have never been aware in my career of, as a lawyer or a judge, of any decision of any court in the country, and I'd be happy to take any court in the country, federal, state, including its territories, that says that a Rule 68 offer constitutes substantive evidence of an accord or of an established fact. The rule by its express terms says that the offer expires automatically, right?
It does, Your Honor.
Okay, so how was it pending months later? I have two questions. Number one, how would it be pending? And the bigger question is, how can a court rely on an offer substantively at all?
So those are two very good questions. The number one, I think you are correct that I did misspeak. It wasn't pending, but I think the intent of the parties when they went to that March 11th, 2020 hearing was to have open discussions about that, whether it was before Commissioner Sagers or outside of her presence. And that did occur, and ultimately they couldn't come to agreement. Now, when it comes to what that offer means, I think it's important because I think we can tie this to 78B12203 Section 8. Even if it wasn't the Rule 68 offer that Commissioner Sagers relied on, if you look at Section 8A of 78B12203, it says income may not be imputed to a parent unless that parent stipulates to the amount implied. She asked in open court, and this answers the other questions, Your Honors, in the record 4943 through 4949, if Mr. McGarry was willing to be imputed to that, and he affirmed that he was. So the reason why that $30,000 was also taken into consideration was the express agreement of Mr. McGarry that he would be imputed to that $30,000 amount. And that's how I believe Commissioner Sagers got to that amount for purposes of child support, because it was an express agreement of Mr. McGarry.
But did the other side, did the other party ever stipulate to that?
I don't believe that she ever did, but I think it's important to look at the statute as it reads, because it's an or, it's not an and it doesn't use the plural parents, it uses a parent. And so when I look at contested cases, when you read the last section of subsection 8A, it looks at if it's contested between the parent who's being imputed, not to a parent who disagrees with imputation.
So if a party shows up at a hearing whether it's scheduled as an evidentiary hearing or not, and says, I'm willing to be imputed this amount of income, that cuts off the opposing party's opportunity to present any evidence whatsoever in any context on the issue?
I think the way that that statute reads is if they agree to be imputed and the judge or the commissioner accepts that imputation, I would argue that it does. Any other questions on the $30,000 issue?
Well, yeah, I have a couple of questions. Number one, there seems to be something of a due process problem here. Nobody's really calling it that. But when parties bring something to a court's attention, whether by way of a petition for divorce or a civil complaint or whatever else, it is anticipated that the court, if it's not settled in the meantime, is going to resolve the matter by some sort of evidentiary hearing where the court takes evidence and makes findings of fact. And at the end of the day, in this case, it doesn't seem like there ever was an evidentiary hearing on the issues brought to the court's attention by the pleadings, nor were there ever findings of fact. The commissioner's order that was signed off on by the court has just one finding of fact, and then it just proceeds into the order, and the finding of fact has nothing to say about income or anything else. So it seems like, don't we have some sort of process problem here about putting evidence on and letting the court make findings from that evidence that just is missing here?
I think that's a good question. I think if we look at the docket, there were numerous filings, both adversarial proceedings that went on in this case, discussing the specifics of the income. Unlike a trial, a judge, a commissioner, it's very atypical for a commissioner to do an evidentiary hearing. Most of the hearings that we do are by proffer. And if you look at the actual record, 4943 through 4949, Commissioner Sagers states on the record that she spent several hours looking at the numbers and the incomes of the parties because that information was before the commissioner.
But somebody's got to give these people a hearing at some point, right? Whether it's the commissioner or whether it's the trial court, isn't it anticipated that at some point there's going to be everybody gets their day in court, as people like to say?
Right.
Witnesses come in and present evidence and the court makes findings. That could happen conceivably at the commissioner level, although you're right, it rarely does. But usually that happens at the trial court level. And that step just seemed to have been skipped here. And I guess I wonder if you see any problem with that.
So I think the problem could lie within Rule 108 of the Utah Rules of Civil Procedure, because like I said, I think the record's full of arguments on what Mr. McGarry's income was and that we defended or we said was not accurate. And Sarah continued to bring up those arguments. So the Commissioner Sagers was well aware of what the incomes of the parties were, what the arguments were for the incomes of the parties were, and that's why she came to the imputation. So if you look at Rule 108, I think what you're referring to is when would she get her day in court? It's through the objection to the recommendation if she really wanted to go have a hearing on that. But the way Rule 108 is construed, if you look at 108D1, the court is not required to have a hearing. It says the judge may have a hearing. Yes.
Okay. The judge may hold a hearing on any objection, regardless of what the objection is about. But if you go down to D3, if the hearing before the commissioner was in a domestic relations matter other than a cohabitant abuse protective order, that's this case, isn't it?
Yes, but I think you have to go on to read as well. And so to present testimony and other evidence on a genuine issue of material fact related to custody. So the way our practice has been amongst family law attorneys, we pretty much can be guaranteed a hearing if it has to do with custody. But then I think we have to go on to
an evidentiary hearing, yes. But in D3B, you still get a hearing at which the judge may, even if it's not custody, you still get a hearing at which the judge may require testimony or proffers of testimony on genuine issues of material fact relevant to issues other than custody. So based on that provision, didn't Judge McKelvey at least have to give these parties a hearing of some kind?
So I think if you look at D3B, like you were referencing, to hearing which the judge may require testimony or proffers. If he doesn't require testimony or proffers, what would that hearing be, right? So I think this is an opportunity for the court to clarify what that means, because there's been plenty of times at our firm when we wanted a hearing and it's been denied, and the courts continually rely on D3B that they're not required to give that hearing if it doesn't resolve, if it's not connected or related to custody. So the way I read that and the way I've had to come to terms with that is that if it doesn't relate to custody, the judge may require testimony or proffers. If the judge isn't going to require any testimony or proffers, there would be no hearing because there would be nothing to discuss. So I think that's the way that Judge McKelvey didn't require a hearing.
Well, okay. Thank you. I appreciate that argument, and I get that. And there's been some confusion on that point. But let me ask you about 108F, which is going to the question I had a minute ago about findings of fact. Right? There never seem to have been any findings made here. And 108F says that the judge will make independent findings of fact and conclusions of law based on the evidence, whether by proffer, testimony, or exhibit presented to the judge, or if there was no hearing before the judge, based on the evidence presented to the commissioner. 108F seems to at least imply that at some point, whether in front of the commissioner or in front of the judge, if the judge is going to be required to make findings, there needs to have been an evidentiary hearing at some point. And yeah, if an evidentiary hearing has already occurred at the commissioner level, the judge could conceivably look at the transcripts of those and make findings from those. But at some point, doesn't 108F contemplate that where findings are required, there needs to be an evidentiary hearing at some point?
I think because it says based on the evidence presented to the commissioner that he can go off the evidence that was provided to the commissioner. And again, not to keep reiterating the 4943 through 4949, but there's various findings of facts that Commissioner Sagers did find. Number one, that the fees were getting outrageous and it wouldn't benefit the minor child or the parties to continue to litigate. So in her equitable powers, that was one of the reasons why she came to a recommendation for a final order. And then it's the best interest that the case to be resolved, as she spent several hours looking at the document, and then she gets into the incomes of the parties. So I think we're making an assumption that Judge McKelvey didn't make independent findings of facts and conclusions of law just because he signed the order.
Where did he make the independent findings?
That's something I don't know. It's not part of the record. I'd have to assume that he took time to read the pleadings, that he took time to read the ruling, and then after he was done, he looked at the order that was approved by form and drafted by our office, that was consistent with what he believed the facts and the evidence to be, and that's why he signed the order. I don't think
the order doesn't recite any evidence, right?
It does just it's just the one, if I have it right here before me.
Right. Well, Judge Harris just quoted it.
Right.
It essentially says this case has gone on too long. It's being too expensive, and I don't think it's in the interest of the minor child. And so your position is that if a court makes that finding, regardless of anything else in the record, they can just declare, I don't even know what adjective to use. They would just declare the matter so badly needs to be summarily decided that that's it. They can just decide. Is that what you're saying?
What I'm saying is I think although he signed this order, there's nothing in Rule 108F that requires him to produce independent written ruling. And so I have to assume that Judge McKelvey took time to go through the docket, to go through the hearing, to go through the audio, whatever it was, and found that this was an accurate reflection of his independent findings and order.
One of the lucky things about this current argument is there's a case called Day versus Barnes that you've all discussed in the briefs. And not only did I write it, but the other two members of that panel were Judges Harris and Forster. So you have the Day versus Barnes panel reconstituted here. How do you reconcile what we said in that case with what happened here? And I thought we were clear in Day versus Barnes about the actual findings that need to be independent. Did you find Day versus Barnes to be ambiguous in that regard?
I did not, and I think, and I understand where your justices are getting at, and would it have been ideal if Judge McKelvey made very, very specific things in addition to what Commissioner Sagers did? It would, but what we have is the record, and I have to assume that he made those independent findings.
There's not a minute entry, and I would grant you that kind of an open question is a court, I think, could enter a minute entry. I'm not endorsing this practice by any means, but it seems like a court could say, I've reviewed all of the factual findings that the commissioner made. I've reviewed the record, and my findings are identical to the commissioner's. Kind of a lazy way to do it, but I think under circumstances and in a simple case, that might in fact be the best way to do it. But it seems to me like your real argument is that the judge must have made independent findings and had a conscientious review because of the passage of time. That this case sat on the district court's docket for a number of weeks, and that we should assume, just based on that, that the district judge actually reviewed this and made independent findings. That is your position, right? It's the passage of time.
That is part of my argument that yes, it was a passage of time, but I also have to give good faith to Judge McKelvey that he would not sign an order blindly, and especially an objection to the recommendation, without taking serious thought, reviewing the pleadings, and then coming to his own rulings and orders, which in this case were consistent with the order that was submitted to Commissioner Sagers. I see that my time's out. Any other questions for me, Your Honors?
I do have one question, and that has to do with the imputation of income to Mr. McGarry. I'm still struggling with this a little bit, and he may have acknowledged an offer that was made in front of Commissioner Sagers, but the district court didn't make any separate findings about either that Mr. McGarry specifically stipulated to that income level. All the order says is that income is imputed, which is based on his Rule 68 offer of settlement filed herein. Even if we accept that Rule 68 offer of settlement is some sort of admission of fact, that finding isn't sufficient to impute income to somebody, is it?
So I think it is, because again, if you look at the record, there was a direct question to Mr. McGarry if he was willing to be imputed at $30,000. And I think it's based on 78B 122038 by stipulation, if he agrees to that, I don't think the court needs to find additional findings because he's agreed to be imputed at $30,000. And the court found that to be an accurate amount, or at least an amount that would be equitable in this circumstance.
So Ms. Ward's disagreement with that, apparently she still has a disagreement with that. There's no opportunity as soon as one party stipulates, okay, impute this amount to my income, there's no opportunity for any sort of dispute about that.
So that's why I was going back at the start to the way that the statute reads. I think that's a statutory issue, because the way I read the statute is it appears that if he agrees and the court accepts it, then that's final. And if she doesn't agree with it, she can object to the recommendation, which she had done, but that didn't change anything in this case. Any other questions for me?
Our rules seem to allow for a district court judge to, it recognizes the process, and this goes back to a decision called OHMS, that commissioners are limited in what they can do. And so it allows the district court to countersign a commissioner's order, and that doesn't affect the objection that's pending. Did Judge McKelvey actually ever rule on the objection?
Yeah, through a minute entry, he denied the objection.
That's right. Yeah, that's right.
And then I believe shortly thereafter, that's when he signed the order on May 22nd.
Right. No, you got that right. Yeah. Sorry.
Thank you, Your Honors.
Thank you, Mr. Olson. Ms. DAKIC?
Yes, thank you. May it please the court. So going back to the issue of non-disclosure of income, it's not correct that Mr. McGarry is only a partial owner. He's the full owner of Iron Mountain. Under Rule 26.1, his financial declaration had missing pages. He was required to file a full financial declaration. He did not do that. The only subpoena that we were able to obtain and actually get documents or records for from the tax commission was for Iron Mountain, but that's when we saw additional flow through income from these other entities. And so again, he has not made a full financial disclosure has been represented here today. Yes. Yes.
So back to the questions I was asking the first time you were talking in this case. Can you we review rulings of the trial court generally. We don't generally review a litigant's behavior unmoored from the decisions the trial court might make about that. And so in this context, I guess I wonder if you can point me to a ruling of the trial court that you are appealing with regard to these disclosure issues.
So with the disclosure issues, let me just pull it up here. So we have it in our briefing where the commissioner had ordered full disclosure, and essentially what's happened is there's been multiple orders for disclosure, but there hasn't actually been disclosure. So the main order I can point to is from that March 11th hearing where the court apparently accepted the fact that there had not been a full disclosure and just said they were making a final order. The problem with the commissioner's ruling, and this goes back to one of your previous questions, is that there were no findings of fact or conclusions of law, essentially, other than the commissioner saying that she thought the order was fair. But the only reason she came to that conclusion, of course, was because Mr. McGarry said, yeah, impute me at $30,000 a month. Of course, he's going to say that if he's making $50,000 a month, right? He'll say, impute me. But where we're saying we actually want to know the real numbers. We actually want this child to be supported to the full extent he should be supported. Give us your real income. Yes.
I think this goes back to a question that Judge Harris asked, and I just want to make sure I understand your position. It seems like prior to this hearing, in an August hearing, the commissioner said discovery is closed. You can prepare for trial and you can get the information you want via subpoena. And by my review of the record after that, there was in fact a flurry of subpoenas. And I understand there was maybe some associated litigation about those subpoenas. But did you object to the commissioner saying discovery is closed?
We did object to that recommendation. We have objected.
And what was the court's ruling? Because it seems to me that if what we're talking about is Rule 26 disclosures are faulty, but at some point in time, the court says discovery is closed. Here's your alternate way to get the information that you want. Mm-hmm. And let's say that you did object to it. It doesn't appear to me that you've appealed that ruling, have you?
So we did name that ruling because that order on appeal. Let me get my exact docket. So essentially what happened though, as part of that hearing that you were just referencing, is that Commissioner Sager said, everything will be certified going forward and Judge McKelvey will decide. That was that earlier hearing. And then when we came back on this March 11th hearing, instead of the commissioner's prior order that Judge McKelvey will decide, she said, I'm entering a final order. This is it. This resolves everything between the parties. So we've included that. We've stated both of those decisions. Let me see. Let me just double check my briefing. I believe we had both of those in there as being the orders because we named several of what. And
yeah, I'm looking right now at your blue brief section A, which is your part. You quote the rules, the disclosure rules, and detail all the things that you think Mr. McGarry should have handed over.
Right.
Pages 20, 21, 22, 23 is sort of where that argument is. I don't see a single reference in any of that to a ruling by the trial court. It's all about what Mr. McGarry didn't do. And this is the way a motion to compel before the trial court should be briefed. Right. In front of us, we need to know exactly the ruling you're contesting from the trial court about this. And there's just nothing to grab onto here unless you can direct me here.
Well, we did file our, on the notice of appeal, we have listed the orders on appeal. And so that's where we're listing what we're objecting to. Even if we were to go to trial right now with the limited bits of information we have and had an evidentiary hearing before Judge McKelvey on those pieces of information, it's certainly better than not getting to have a trial at all. I did make a statement in my prior argument about this being a due process issue where Ms. Ward is entitled to her day in court, right? She's entitled to a trial. Again, this is a case that so badly needs to be decided that it should especially get a trial or an evidentiary hearing. I do see what you're saying, Your Honor. Maybe we're coming to the Court of Appeals saying, help us, because we've tried all these different avenues for relief with the trial court, both the commissioner and with Judge McKelvey, and we're not getting the relief that we're entitled to, that Ms. Ward is entitled to. She certainly should be allowed to, I mean, without having, I want to go to what the court was saying about Dave v. Barnes, as well as Davis versus Davis, the older case about this, where there has to be independent findings of fact and conclusions of law, independent review of the evidence and the law. That just hasn't happened here. I mean, having a 15-minute hearing with the commissioner where she doesn't enter sufficient findings and she says she just thinks it's fair, we have no idea. I mean, she might say, I've looked at the, docket over several hours over the past several years. We don't know what that means. We can't even appeal that. We're having a hard time appealing this or pointing to something specific when there hasn't been that sufficient review and the findings made or the conclusions of law to even know, to be able to marshal the evidence, to know what's in error. That's part of our issue here, and that's what we're coming to the court with. So I understand what you're saying about the way that some of the argument has been set up as far as what this court reviews, but I do believe we've set forth the standards correctly in saying that there's an error for the non-disclosure of income under the statutes and the rules, that there is the commissioner making a final order that's in error, and then the lack of independent review. That's the real issue here. And just taking pieces of Rule 68 settlement offers that were never accepted, I mean, they automatically become void at that point. But instead, we had a 15-minute hearing where the commissioner decided to take bits and pieces from those unaccepted offers and create a final order. And that's just something that is not appropriate in this case. And so we believe that vacatur is appropriate here on remand, that Ms. Ward is in fact entitled to a trial or evidentiary hearing. Again, even if the court finds a lacking in our a lack of objection to that prior order, because discovery did close and I was not counsel on the case at that time, but we at least got the information or the order from the court allowing subpoenas still. And even when I tried to move forward on that part of the court's order, we're met with resistance and objections from Mr. McGarry, and those motions are still outstanding.
Ms. Goddard, what is your response to Mr. Olsen's the way that he construes 803? Is your client just sort of out of luck as long as the other party stipulates to a level of income that automatically imputes that level of income to that party, and there's no opportunity? It means that that's no longer a contested case?
No, our position is we completely disagree. Just because he says, I want you to impute me, I'll accept being imputed at this income, Ms. Ward is still entitled to have a review by the finder of fact in the court. The court needs to look at that and make a decision. We have no idea how Commissioner Sagers even came to that amount of income, other than assuming the fact that she pulled it out of the settlement offers. But the problem with that is, again, we don't know if it's an error. Ms. Ward is entitled to know what the actual income is. Part of her due process rights is to have a trial to review, because it is still contested. It would still be a contested issue. Just because Mr. McGarry says it's not contested doesn't mean that Ms. Ward has to accept that. And based on that, she should still get her day in court. based on the limited evidence she has, what she was able to obtain during the discovery period, what we've obtained with our one subpoena, what we are still waiting on our other subpoena information for the court to rule on that part, on that motion with that subpoena. Even with that, moving forward to trial with that would be more sufficient than the court just telling Ms. Ward, you're out of luck, you don't get a trial. That's not due process. She is absolutely entitled to still contest that, and she still does. She doesn't have to just accept Mr. McGarry under the rule saying, well, I've agreed to be imputed. In fact, he's not to just be imputed under UCA 78B 12-203, subsection 4B, or I'm sorry, subsection 5A. It says gross income. So we're looking at gross income here, which is all income, should first be computed on an amount basis and then recalculated to determine the average gross monthly income. And the rule goes on to talk about, or the statute goes on to talk about it being annual and then looking at monthly, but we've never been able to get that information. Ms. Ward does not have to accept this. She should be able to have evidentiary review. She should be able to present her evidence that she has been able to obtain, her witnesses. She should be able to have an independent finder of fact to look at the evidence and make that decision. And so it's not appropriate or proper to say just because Mr. McGarry essentially agrees to it, that Ms. Ward has to accept it. That's not the way that our judicial system works. And so it shouldn't be going that way in this case. Yes, Mr. McGarry, he certainly has tried to hide his income. He's succeeded up to this point. And so we're now here asking this court to give us some relief and remand the matter with vacature of the prior order so we can move forward and have a trial, even if that's based on the limited evidence we have, even without objection to the prior closure of discovery, we still want to move forward and have a trial. And I'll submit on that if the court doesn't have any further questions.
Doesn't appear that we do. Mr. Olsen, if you would mind returning. Thank you, counsel, for your arguments today, and thank you specifically to Ms. DAKIC for spending so much time with us today. We appreciate it, and thank you, Mr. Olsen. Was this your first time appearing in the Court of Appeals?
Yeah, it was. So thanks for being generous and nice to me. You weren't too scary. I had nightmares last night, but it went okay.
Definitely went okay. We very much appreciate your arguments, and we will take this matter under advisement and render a written decision as soon as we can.
Thank you, Your Honor.
We will be in